Today, we have an interesting case out of the Eastern District of Missouri Court of Appeals, and it concerns a novel question. Is an app for your phone product? Let's talk about that. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. The backstory in this case is that a couple of youthful offenders who, that may be the nicest euphemism I can come up with for them, attacked a Lyft driver. Basically, they used the Lyft app to book a ride with one of the reusable credit cards or reloadable credit cards that are not tied to a particular name. So they just used something like John Smith, and they placed this request for a ride with Lyft. The driver went out there in his nice car and they carjacked him. And in the process, they killed him. And the family wanted justice. And of course, as to Lyft, he is not an employee in Missouri. He is essentially a independent contractor. So any insurance that he would have to protect him from injury, well, that's on him. So in order to get his family some compensation, the lawyers who represented him did something that I think is quite novel. They decided to sue under a product liability theory. And the real question in the case, at least the one that caused the court to spill the most ink in this case, is whether an app for your phone is a product. It's a really interesting case, and let's dive into it. So this is the opinion. It's Rochelle Amir versus Lyft Incorporated, and Christopher D. Morgan and Ajane Barnes. Those are the defendants. Rochelle Amir appeals the judgment dismissing her product liability and negligence claims against Lyft for failure to state a claim upon which relief can be granted. Taken as true, the allegations in plaintiff's petition, and viewing all reasonable inferences therefrom in her favor, plaintiff's claims against defendant Lyft arose out of a September 20 incident where her son was driving for Lyft and was killed during a carjacking after he responded to a ride fraudulently and anonymously requested through Lyft's mobile ride-sharing app, the Lyft app or app. Plaintiff's petition asserts three product liability claims against defendant Lyft for strict liability design, defective design, negligent design, and negligent failure to warn. Plaintiff's petition also asserts two negligence claims against Lyft for negligent training, that's count 4, and general negligence, count 5. For the reasons discussed in detail below, we reverse the trial court's judgment dismissing product liability claims in counts 1 through 3 and plaintiff's negligence claims in counts 4 and 5 for failure to state a claim upon which relief can be granted, and we remand for further proceedings consistent with this opinion. Because this appeal involves a dismissal by the trial court for failure to state a claim upon which relief can be granted, we begin by setting out the general allegations of the petition. The plaintiff is the mother, the defendant is Lyft, a Delaware corporation. The app is an app that Lyft placed into the stream of commerce, and Lyft app permits Lyft drivers to connect with unknown individuals who are requesting automobile rides, and Lyft requires its drivers to accept all ride requests when logged into its app or be subject to potential discipline. Additionally, an individual requesting a ride through the Lyft app is provided via the app information about the driver, including his or her type of vehicle. Lyft operates in pretty much every state, including Missouri. Plaintiff's petition alleges that on the evening of September 28, 2020, underlying defendants Morgan and Barnes were at the time minors supposed to be ineligible to order rides through the Lyft app, met and conspired together to use the app to carjack a Lyft driver. In order to hide their identity, Morgan and Barnes purportedly set up an account in Lyft using a false name, a false email address, and an anonymous form of payment. Morgan and Barnes then used their account app to fraudulently and anonymously request a ride from a neighborhood in the city to a destination miles away. The Lyft app then directed the ride request to the plaintiff's son, who accepted the request, Arrived at the location around 11 p.m., was carjacked, shot, and killed. Plaintiff then filed a petition in the instant case, and at the district court, or I'm sorry, at the circuit court, the petition was dismissed because, among other things, they said that the Lyft app was not a product. The trial court entered a judgment granting defendants' motion for and dismissing counts 1 through 5, specifically finding that Lyft's arguments in its motion to dismiss that it not wasn't an app, or I'm sorry, that it wasn't a product, had merit. This appeal followed. Before we actually get into the opinion here, the key thing that I want to make known is that in Missouri, the criminal acts of third persons are not reasonably foreseeable. So there is a huge problem with a negligence claim when it relies on the negligence of a party in not anticipating a criminal act. In fact, I was involved in a case against McDonald's Corporation where our client was parked at a McDonald's, got out of his truck, and he was the victim of a drive-by shooting. And as he ran to the door of the McDonald's in order to escape being shot by a truck that was coming up fast in the driveway, they locked the door so that he couldn't get in, and he wound up being shot and paralyzed. And the general ruling in the trial court in that case was that, he had absolutely no way to predict, or McDonald's had no way to predict that this would be a criminal act, even though in the neighborhood there were numerous criminal acts of the same type. And McDonald's, I think, skated on that case. We lost it, but I believe they got kind of a sweetheart deal out of the judge based on his earlier determinations. And I've always felt really bad for the victim who was injured in that case because he got no compensation whatsoever. But the whole issue in those cases is that if there has not been something that would put a owner of a business on notice that there are criminal acts that are occurring that might conceivably affect its customers, well, then you can't sue that individual when you get hurt by criminals who either burglarize or terrorize that individual's business. So that's sort of in the background here. It doesn't really come out as much as I think it probably should in this opinion, but particularly with respect to negligence, the idea is that Lyft would have to be aware of similar incidents using similar methods and their drivers being injured or carjacked in those situations. I don't think that we have that information because this was dismissed at an early stage, and so there likely wasn't a lot of discovery at this point. It will be interesting to see how this comes about once they actually get into discovery. And I would also point out that this could still go up to the Supreme Court, and the Supreme Court might reverse the Court of Appeals, finding that it isn't a product. But I thought the Court of Appeals resolution here was pretty good. So the court starts out by asserting the law regarding product liability claims. Plaintiff can bring a product liability claim under a theory of strict liability, which is defective manufacture, defective design, or failure to warn, or a theory of negligence, negligent manufacture, negligent design, or negligent failure to warn. The difference between the two legal theories is that while a defendant may be found liable under a theory of strict liability without regard to his knowledge and conduct, a defendant's knowledge, conduct, fault, and the standard of care are relevant considerations in determining his liability under a negligence theory. Nevertheless, you can bring a claim and you don't have to distinguish between the two because you can plead in the alternative in Missouri. So all of these counts are based on the same operative factual allegations, counts 1 through 3 in this complaint, and that is defects in Lyft's app relating to the app's alleged failure to contain protections for Lyft's drivers, including plaintiff's son. For strict liability, defective design claims, your plaintiff has to allege the defendant sold a product in the course of its business. The product was then in a defective condition and was unreasonably dangerous when put to its reasonably anticipated use. The product was used in a manner reasonably anticipated, and the plaintiff was damaged as a direct result of such defective condition as existed when the product was sold. In sum, as to relevant to this case, the proof of a defect or a hazard in a product is an essential element of plaintiff's claims for negligent design and negligent failure to warn. Based on the foregoing, in order for the plaintiff to sufficiently allege product liability claims for strict liability, defective design, and negligent failure to warn, her factual allegations must allege, among other things, that the allegedly defective Lyft Act was a product. Whether a mobile ride sharing application like Lyft can be considered a product for purposes of a recognizable product liability claim is an issue of first impression in Missouri courts. In other words, there's never been a case just like this. Prior to the incident case, Missouri courts have applied product liability to harm caused by tangible items, including a chain and ratchet system, cigarettes, a driver's seat in a car, and plane parts. Missouri courts have held product liability law does not apply to harm caused by a scouting program, the supply of electricity, medical services, and services in general, finding those items are not considered a product for the purposes of a product liability claim. None of these previously mentioned cases are on point here because a mobile ride sharing app, like the Lyft app in this case, is not directly comparable to a tangible item, a scouting program, the supply of electricity, or a service, medical or otherwise. They refer to a case out of Kansas holding that the Lyft app is not directly comparable. As alleged in plaintiff's petition, the Lyft app was designed, created, assembled, inspected, marketed, sold, and otherwise delivered into the stream of commerce by Lyft in the regular course of business. Don't you just love the way lawyers cover every conceivable way this thing could have gotten into the stream of commerce? The Lyft app is a mobile ride sharing application that's available to the general public for anyone to download with a smartphone. Individuals can request a ride from a Lyft driver after opening a Lyft account on the Lyft app and submitting a form of payment. The Lyft app provides a service in providing transportation to members of the public by connecting individuals purporting to seek rides with Lyft drivers. And the September 2020 incident during which plaintiff's son was killed took place after son and his perpetrators were connected through the Lyft app. So, based on the above allegations, we find the petition avers Lyft app has characteristics of both a service and a tangible product. So that creates a bit of an issue. On the other hand, Lyft's role is different from a mere service provider because Lyft designed and placed the Lyft app into the stream of commerce for the general public, putting Lyft in the best position to control the risk of harm associated with the app, caused by design choices similar to designers of tangible products. Accordingly, and as aptly stated by a Florida court faced with the same issue before us here, our court must recognize the changes rippling through our society as a result of the technology at issue, and deciding whether the Lyft app should be forced into one of the old square holes where none are a perfect fit just doesn't work. The court finds it's not appropriate to force it into one of those pre existing legal categories and instead basically says it's a product. Instead of determining whether the Lyft app can be considered a product for purposes of a recognizable product liability claim in Missouri, we find precedent from the District Court of Kansas to be instructive. In Doe versus Lyft, the plaintiff filed, among other things, a product liability claim against Lyft, alleging she was assaulted by a Lyft driver after the plaintiff used the Lyft app to request a ride. The plaintiff alleged the Lyft driver had a criminal record and did not possess a valid driver's license. The plaintiff also alleged that when the driver filled out a job application on the Lyft app, she submitted one, a legitimate picture of the driver, and two, a driver's license with a picture of someone else because the driver had fraudulently used another person's driver's license for her application. Lyft moved to dismiss the plaintiff's product liability claim on the grounds that the Lyft app was not a product and therefore product liability law did not apply. The Doe court denied Lyft's motion to dismiss, finding the Lyft app was a product subject to Kansas product liability law because the facts established that the Lyft app was a software or algorithmic product with sufficient similarities to a tangible product. So that's essentially the finding that they make here. Furthermore, the court found that the plaintiff met the aforementioned standard because the plaintiff alleged the design of the Lyft app was itself defective in that the app did not properly distinguish between the legitimate picture of the driver and the one submitted with their job application on the license. So we agree with the reasoning of Doe versus Lyft. It's a mobile ride-sharing app that's much more similar to a product than it is a service. And in this case, we find plaintiff's petition sufficiently meets both parts of a test for determining whether a mobile ride-sharing app is a product for purposes of surviving a motion to dismiss. First, the facts alleged established the Lyft app with sufficient similarities to a tangible product. Additionally, plaintiff's petition alleges the Lyft app was developed and placed into the stream of commerce so Lyft could operate a transportation service to the public for profit. To receive and accept rides from purported passengers, Lyft drivers must download the app to a smartphone and then use the app. And three, to request a ride from a Lyft driver, purported passengers must download the app to a smartphone and then use the app to create a Lyft account and submit a form of payment. Taking these allegations as true and viewing all reasonable inferences therefrom, the Lyft profits from the Lyft app and creates a demand on the reliance on the app for Lyft drivers and customers. So basically, they decide that it's a product and they reverse the dismissal of the petition by the circuit court. Again, I want to point out this is not final because the Supreme Court has the last word. And although there's nothing online to tell me that they have filed a motion to have this reconsidered or transferred to the Supreme Court, that is pretty much standard practice when you lose on a motion like this at this level. So we'll have to see what happens, but I'm pretty sure that this is a good reading on the product liability law. It follows the law in both Kansas and Florida. So it's not the Missouri court just standing out there on a limb waiting for somebody to saw the limb off behind them. That's always a comfort to the courts. And again, it gives some degree of uh, comfort to the public because they're not just creating stuff out of whole cloth. They're reasoning through the situation that's presented by novel technology and the way the thing works. Because realistically, when you download that app, you are downloading a product onto your phone, just the way you would if you were downloading Tetris. So that's what I have for you today. Thank you very much for watching. I hope you found this interesting. Let me know in the comments or by email. Catch me down here at the beach tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.